the defendant's behavior simply wasn't disorderly. Even taking the officer Steingraber's testimony and his standing in the corner and shouting out these words, words which were not vulgar, words which were not profane, words which were not threatening in any way, shape, or form, words which even the way in which Mr. Rosenberg described it, they were thoroughly sarcastic. If you heard the inflection of Mr. Rosenberg's voice, thoroughly, that was a sarcastic statement. Oh my rights are being violated, my access in passage is being blocked. This was clearly a commentary directed at the actions of the Capitol Police over the preceding months, issuing all of these citations. So just the first element, this was not disorderly behavior. It was not unreasonably loud. And this was not something that was done during the middle of a church service when everybody was being very quiet. It was in the midst of a group of 100 boisterous fourth grade children. And it was a statement that was made loud enough to be heard over those 80 to 100 children, but it wasn't done in a way that could possibly be construed as threatening or offensive behavior. Now, even if it were offensive behavior, Your Honor, it's behavior that's protected by the First Amendment of the United States Constitution. So if this court were to find that the defendant's behavior was potentially unreasonably loud, and I don't think there's evidence here to support that to a reasonable degree of certainty by evidence which is clear, satisfactory, and convincing. I don't even think there's evidence here to support it by a preponderance of the evidence. But if the court were to consider that Mr. Smith's behavior was unreasonably loud or boisterous, then the court needs to consider the application of the First Amendment. And there was a clear political motivation to Mr. Smith's statement. And this is a statement that was made in the Capitol Rotunda, a location that has been described by the federal courts and by every circuit court in this county as a public forum. So if indeed the court even were to consider Mr. Smith's behavior to be disorderly, the court must consider the application of the First Amendment, as the Wisconsin Supreme Court has indicated in the case of Douglas D. And when the court considers it within that context, even if Mr. Smith's behavior were somewhat disorderly, it would be privileged by the First Amendment. So the court must find the defendant not guilty. Thank you, Your Honor.
Any reply? Your Honor, replying to Attorney Jambois' comments regarding the First Amendment, even though some speech itself may be protected, conduct associated with the speech may not be protected and may be subject to prosecution as disorderly conduct. It's the combination of the conduct and the circumstances that is crucial to applying the disorderly conduct rule. For example, unreasonably loud speech, even if the words themselves are protected by the First Amendment, carries with it the non-speech element of excessive volume. The evidence shows that Mr. Smith's conduct here was unreasonably loud, it was boisterous, and it provoked a disturbance and breached the peace in the Capitol's public area. Looking at the circumstances, we had a group of fourth graders who were there for a tour. They had come in at their scheduled time to come in for the tour at 1 o'clock, and Mr. Smith was unreasonably loud, and he was staggering about, and it caused the children to be scared and to back away. That's a disturbance. His conduct caused that disturbance, and that's why his conduct was disorderly.
All right, thank you for that. Standards are the same basically as the standards that apply in a criminal disorderly conduct, which I happen to see every day in terms of criminal rotation I'm on, so I'm very familiar with disorderly conduct. And the first element, as was pointed out, is whether Mr. Smith engaged in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct. There's no indication that he engaged in violent, abusive, indecent, or profane conduct. arguable whether it would be boisterous or unreasonably loud or otherwise disorderly conduct. Those are the three that it might be. I think it's a close call on whether it is unreasonably loud because of the circumstances with 80 to 100 young people, fourth graders, making the noise that fourth graders will make. I know from having been in the building many times that it echoes in there quite a bit, so I'm sure it was quite loud. However, the officer was able to hear, and Mr. Rosenberg was able to hear quite clearly Mr. Smith's comments, so it had to be loud enough to get over the din of the children. Granted, neither of the witnesses were that far away, so it's impossible for me to know what exactly the decibel level was. So I will find that it was unreasonably loud, that he raised his voice quite a bit. Then we get to the question of whether the conduct of the defendant under the circumstances as they then existed tended to cause or provoke a disturbance. And the state provided the statutory, well, I shouldn't say statutory, the jury instruction for disorderly conduct. And it's understood that the general phrase otherwise disorderly conduct means conduct having a tendency to disrupt good order and provoke a disturbance. It includes all acts and conduct as are of a nature to corrupt the public morals or to outrage the sense of public decency, whether committed by words or acts. Conduct is disorderly, although it may not be violent, abusive, indecent, profane, boisterous, or unreasonably loud, if it is of a type which tends to disrupt good order and provoke a disturbance. The principle upon which this offense is based is that in an organized society, a person should not unreasonably offend others in the community. This does not mean that all conduct that tends to disturb another is disorderly conduct. Only conduct that unreasonably offends the sense of decency or propriety of the community is included. It does not include conduct that is generally tolerated by the community at large, but that might disturb an oversensitive person. It is not necessary that an actual disturbance must have resulted from the defendant's conduct. The law requires only that the conduct be of a type that tends to cause or provoke a disturbance under the circumstances as they then existed. And then the instruction goes on to tell the jury further how they're to interpret that phrase. In this case, if Mr. Smith had gone right up into the face of the fourth grader and yelled the same statement, inches from one of the little children, then I would agree that would be disorderly conduct. If Mr. Smith hadn't left the scene immediately, well, it's unclear from the record if it was immediately, but it was fairly quickly, I can infer from the testimony. But if Mr. Smith had not left very quickly, and he had plunged back or plunged into the crowd of the fourth graders and other parents who might have been there after saying this, and was then staggering around or like sort of playing pinball, if you will, with the children and by bouncing around in there and acting strange after making the comment, then I would find that that was disorderly. If he had stood right next to the children and continued to yell very loud repeatedly what he was saying beyond the one time, then I believe that could be construed as being disorderly conduct. But here, what Mr. Smith did, although maybe not how I would hope that he would comport himself, I don't believe that what he did is disorderly conduct as defined in the meaning of that term, as I just indicated. It may have been alarming or startling to some of the people. They may have stepped back because of that. They may not, understood the context of everything that's been going on in the Capitol. Maybe some of the adults did, I don't know. So I can understand why the children might step back, or even an adult. But then Mr. Smith apparently left the scene. Part of what the fourth graders are there in the Capitol to see is democracy in action, and democracy is sometimes noisy and maybe sometimes even a little uncomfortable, but I don't think in this case that what Mr. Smith did rises to the level of disorderly conduct. I think it warranted asking the person not to do it again. I think it would warrant asking a person to move along or get away from the children perhaps, but I don't find that it rises to the level of disorderly conduct. I don't need to determine whether a First Amendment affirmative defense applies here because I'm concluding that based on the facts, it does not rise to disorderly conduct. So the citation then is dismissed for failure to meet the burden of proof. Any further record that either side wants to make here today?
No, Your Honor.
Your Honor, I would note that in all of these cases, I filed a brief and a motion to have the case caption amended to reflect it's the Department of Administration versus Mr. Smith.
And I think I previously denied those motions.
No, I think you took them under advisement. In any event,
Well, I'll have to go back and look.
it could be that you denied them, and I'm mistaken, because I acknowledge that I've got a terrible memory, and but my understanding is that you had taken them under advisement. In any event, I will be filing a motion for costs, regardless of whether the matter is amended, or the caption is amended. This was an action by the Department of Administration. It's being prosecuted by the AG's office, but it's by the Department of Administration. It can only be brought in the name of the Department of Administration, but whether it's brought in their name or in the name of the state, it is an action by the Department of Administration, an administrative agency against an individual. And under Wisconsin's Equal Access to Justice Act, found in, I think it's 814.265, the defendant is entitled to recover attorney's fees. So I'll bring a motion, I think I've got 30 days from the date that the matter is decided by this court to bring such a motion, to bring a motion for costs.
Your Honor, the issue of the amending the caption is moot at this point. The case has been dismissed.
All right, that may very well be, I don't know. I thought I had ruled on that in some case, but it would have been about a year or so ago. I don't know, Mr. Gabrisiak, you probably don't remember either, but that's fine. Unlike disorderly conduct, which I'm familiar with, and have a feeling for what, that this is an issue that's much more complex, so I'm not prepared. Obviously, you're not asking me to rule on it here, so.
No, I'm not, Your Honor.
So I guess I'll wait to see what Mr. Jambois files, and then the state, you can be rest assured, will have an ample opportunity to respond to that.
Thank you, Your Honor.
And then if need be, perhaps if you do file something, Mr. Jambois, I'll just set a briefing schedule with like a 30-day, 1-week reply kind of period.
Thank you, Your Honor.
Okay, anything else before we adjourn?
No, I think that covers it.
All right, then we'll go off the record.